Hi, I'm Andrew DiPaola from New World Title. I'm one of the attorneys here, and I wanted to briefly explain the forms of ownership. There are a number of ways you can take title to property, so I just wanted to give some highlights about those and explain that. I'm going to talk about three forms of ownership: tenants by the entirety, joint tenants with survivorship, and then tenants in common. So these are situations where you have multiple owners. Obviously, if you're only going to have one owner of the property, they take title as sole owner. So the three I'm going to talk about really just apply when there's two or more persons taking title of the property. So first, tenants by the entirety. This is when we have a married couple. This is only available to married couples. What the benefits of the tenants by the entirety are is the right of survivorship and then also a judgment protection. And by survivorship, I mean when you take title of tenants by the entirety, if one of those owners passes away, then title passes to the surviving of those two. So there's that right of survivorship upon the death of one of the co-owners. There's also this judgment protection. So there's a protection from creditors, individual creditors. So if there are two spouses, if there are judgments against one of the spouses, it would not attach to the property. The creditor would have to have a judgment against both of the spouses to attach. The exception to that being is IRS liens. For those, there is no protection when there is an IRS lien. So again, just to recap the tenants by the entirety, there's the right of survivorship, there's the judgment creditor protection that is limited, and it's only available to married couples. The next one to talk about would be the joint tenants with the right of survivorship. So again, this is where you have two or more persons taking title to property. And as it says in the name, there is a right of survivorship here. So it's similar to the tenants by the entirety in that there is, upon the death of one of the owners, the property is going to pass to the other owner or owners. There's no need to go through probate when you have joint tenants with survivorship. The difference being that there is no judgment protection. So this is going to be when we have two or more persons that are maybe related to each other. They could be unrelated, but it's not for married couples. The thing to remember about a joint tenants with a right of survivorship is that you actually don't need all the owners to join in to a conveyance. Whereas tenants by the entirety, both of those owners, the married couple has to join in to convey the property. The joint tenants with right of survivorship, property could be conveyed without all of them joining in, but it reverts to tenants in common. That leads me to the discussion about a tenancy in common. Again, we're talking about two or more persons. There could be 2, 3, 4, 5 owners, and they could choose to take title in this manner. The thing about tenants in common is you can apportion the interest. So you could have two people, they could each have a 50% interest. You could have 5 people, they could each have a 20% interest, or you could have a lot. I've seen instances where there's 75% to one person, 25% to the other. So it's just a selection by the parties of the percentage ownership interests. With the tenants in common, there's no survivorship. So what this means is if there are two owners as tenants in common, one of them dies, the person that died, their share in the property, their interest is going to pass to their heirs. So it's going to be either through their will, or if they don't have a will, according to what we call the laws of intestate succession. So it doesn't pass, again, no survivorship, so it's not going to pass directly to that other owner. It allows you to kind of set up how you want the property to pass in the event of your death. If you don't want it to go to the other co-owner, you can again do it either by your will or by the laws of intestate succession. The thing with the tenants in common is the property can also be conveyed without the joining of those other co-owners. So you may own a 50% interest, you could convey that 50%, give it away to somebody else. You don't need the other owner to join in to that. So just kind of recapping again the three, we talked about tenants by the entirety, joint tenants with right of survivorship, and then tenants in common. Again, tenancy by the entirety. Married couples, there's survivorship and a limited judgment creditor protection. Joint tenants with survivorship, there is survivorship. It's to two or more persons, any they could be, again, related, unrelated, and upon their death, the property would pass to the survivors of them. And then the tenants in common, which is, again, two or more persons. There's no survivorship, so that deceased person's interest in the property would pass according to their heirs, according to the will, or if they didn't have a will, by the laws set up in Virginia for succession. So I hope that clarifies things. If you have any questions about it, please feel